Very good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. This evening, we have with us today a young, illustrious senior advocate, Mr. S Ponnanna. Sir, we are pleased to have you with us today. I extend a warm welcome to you on behalf of Advocates Association Bengaluru.
Thank you. Thank you very much.
I further take the privilege of introducing today's speaker. Mr. S Ponnanna is son of senior advocate and former leader of the opposition in the Karnataka Legislative Council, late Shri A.K. Subbaya. Mr. Ponnanna is an alumni of University Law College at Bangalore. His areas of practice includes constitutional law, criminal law, administrative law, service law, taxation laws. He regularly appears before various tribunals, high courts, and the Supreme Court of India. He was on the panel of advocates in Karnataka Public Lands Corporation, and he has served as a standing counsel for TV9, Kannada news channel. In 2016, he was appointed as the principal government advocate for Government of Karnataka. In 2014, he was appointed as the additional advocate general for state of Karnataka. Mr. Ponnanna was a special counsel for the state in Justice Kempanna Commission of Inquiry, that is the Arkavati denotification case. He has appeared as a special public prosecutor in one of the sensational rape cases. He was further appointed as a special counsel for the forest development tax matters. He was also appointed as a special counsel for the Honorable Speaker in Upalokayukta removal proceedings before Justice Budihal. He was a special counsel to represent the state in challenging the constitution of the Anti-Corruption Bureau. To his credit, Mr. Ponnanna has various reported judgments, but it is worthwhile mentioning these two reported judgments. One is the 13 MLA disqualification case, which is reported, which he had argued before the Honorable Supreme Court, before the then Chief Justice, His Lordship Altamas Kabir. And one more reported case is Jayalalitha's case, that is state of Anbalagan versus state of Karnataka. This case also, Mr. Ponnanna had argued before the Honorable Supreme Court, and is also a landmark judgment as far as appointment of the special public prosecutor is concerned. He is also a designated senior advocate by High Court of Karnataka. We are very pleased to have you, sir, as our speaker today. Thank you so much. Before we start the session, we have the question and Q&A box active now. All the participants, whoever wants to shoot their questions, they can pass it offline through the Q&A box. Thank you. Over to you, sir.
Thank you, Trivikram. I must congratulate the Advocate Association for this initiative. During the lockdown, they have been very, very proactive. And apart from making necessary steps to take care of the young lawyers, this webinar and also the clerks, where they have given financial assistance to them. They have started this webinar. You have been very active. I have been watching this. The Honorable Chief Justice came in the inaugural session. It was great. Privileged to watch him or hear him. And then Mr. Holla, Ravi Shankar, a lot of young lawyers now in the last 2-3 days. So it is great. I must congratulate them, and I hope they keep up this effort to provide platforms for young lawyers, and also lawyers like me who are not so young but not so old as yet. So thank you, and I congratulate the association once again. So shall we start?
Yes, sir, please.
Now, the evil of disqualification, as the title itself suggests, let me go back to the history of how disqualification law started in this country and whether it is peculiar to India alone. Firstly, you see, let us understand how disqualification and defection works. It is not peculiar to India insofar as defection is concerned. Political defection is part of the political process in several countries. America has witnessed it. England has witnessed it in 1939, where the then Prime Minister defected, and Australia, and several Nigeria, several other countries. But what is peculiar to our country or Indian democracy is the rampant nature of defection. And defection with this whole intention to knock off or topple politically, legally elected governments. Now this is why defection, which is otherwise acceptable in other democracies, is an evil in this setup, and because of the way in which defection has been used. Now, defection is not new to our democracy and to our scheme, but no other country has an anti-defection law like we have as a part of it, of the constitution, of their own constitution itself. Now, if we go back to the history of defection, when the country was governed by virtually brute majority of the Indian National Congress after independence, 1952 election, and thereafter, we did not see any defection at all. In fact, there was zero defection. Defection in the real sense started after the 1960s. So in 1962, if I am not mistaken, I think 1967, out of the 16 assemblies that went into elections, Congress lost in 8. In 7, they could not form a single party government, so they had to go in for coalition. In 1, they retained their government. So that is when the real defection started. So in 1967, the coalition government's common minimum programs was introduced as the first time in Indian democracy. Of course, we are a fledgling democracy, and so it was a new concept. And there started the process of the thinking of defection. Now, the Haryana state is a pioneer, and Haryana has several reported judgments, and we are second in line, unfortunately. Karnataka has also several instances of defection. Haryana is a pioneer in defection law, and in Haryana, there was a government which was formed where for the first time the chief minister himself was a defector from Congress, Birendra Singh. And the famous term that we use, Ayaram Gayaram, started from Haryana's legislator, whose name was Gayalal. He defected in a matter of 15 days 3 times. So between the period, please take note of this, between the period 1967 to 1972, there were almost 142 defections in parliament, and nearly 2,000 defections in various legislatures of the states, and near 212 of them were rewarded with ministries, and one of them became a chief minister also. So this defection had become a rampant process, that it was noticed as an evil and as a threat to the democracy, which was very eroding the very foundation of our democracy. Therefore, for the first time in 1962, Parliament passed, the Lok Sabha passed a resolution that there should be a committee on disqualification, on defection. It was called as the Committee of Defections, to go into the evil of defection, to go into every aspect of party jumping, floor crossing the floors in the house, and to deal with every single aspect of it. So the Committee of Defections was formed with representatives from various political parties, leaders, intellectuals, and they came up with a detailed report before the Lok Sabha. Therefore, based on that report, the anti-defection law was drafted, and for the first time, the anti-defection law was placed before the Lok Sabha as a 32nd amendment in the year 1969. So 1969, for the first time, the bill was introduced. However, it did not go through, it lapsed because the house was dissolved. Then again, in the 48th amendment in 1979, the amendment, the constitutional amendment bringing about an anti-defection law was placed. Again, it did not go through. So there is the reflection of the lack of political will amongst our elected people, representatives. Twice, a bill which was to deal with this evil of defection did not go through, lapsed in the House. And thereafter, finally, in the 52nd amendment in 1985, the 10th schedule was introduced, and suitable amendments to Article 105 and 191 of the Constitution was introduced to say that you are disqualified from being a member if you have acted in contravention to the provisions of the 10th schedule, which is the anti-defection law. Now, the 10th schedule passed the muster of the House and was introduced in the Parliament. So did the amendments to the various articles of the Constitution. Now, the 10th schedule, let me just very quickly take you all through the 10th schedule. The 10th schedule, as when it was introduced, had 8 paragraphs. Paragraph 1 deals with interpretations, basically with definitions. It defines what is the House. It defines what is the original political party, which is of great relevance. It defines the legislature party. Then it also defines what are the paragraphs, that is paragraph 2 to 8 onwards. Paragraph 2 is the most important part of the 10th schedule. Paragraph 2 provides for disqualification on certain grounds. Now, it is like in taxing law, it's like the charging section. So it provides that if you voluntarily give up the membership of a political party from which you are elected, you shall be disqualified. And if you violate any direction issued by the political party from which you are elected, you will be disqualified. Now, this is the gist of paragraph 2, 1 and A and B. Thereafter, of course, it also deals with independent members. Independent members cannot join any political party. If you are elected without being a representative of a political party as defined under the 10th schedule, which is a political party in terms of the definition or interpretation is a party recognized as a regional party by the State Election Commission and as a national party by the Central Election Commission. So if you are independently, you have contested the election, have been elected, you cannot join any other political party. There is a clear bar. But if you are a nominated member, as you all know that there is a process of nomination where the governor nominates to the legislative councils, wherever the councils are available in the state, and the president will nominate to the Rajya Sabha. A nominated member has the option to join a political party, but there is a prescribed period of limitation, which is within 6 months from the date he is nominated, he has the option to join any political party he so chooses. Otherwise, there is no option of joining. Then paragraph 3 dealt with a split. Of course, thereafter, by another amendment to the constitution, it is now deleted, it does not exist. Then the procedures for making a complaint, the speaker's powers, then rules. Paragraph 7 dealt with the restriction on judicial interference. In fact, it cast a total prohibition on courts interfering in disqualification proceedings and judgments and orders passed by the Honorable Speaker or the Chairman of the House, as the case may be, which I will come to later, which has been struck down by the Honorable Supreme Court in a constitutional bench judgment. Then paragraph 8 provides for rules to be framed by the Speaker to carry out these disqualification proceedings. We have framed our rules. Karnataka disqualification rules are in place. Now, as soon as the amendment came into place and the disqualification law was in force, as you can expect, there was a series of challenges to its validity throughout the country, in various high courts, in the Supreme Court. All of them were taken up together in the landmark judgment or the lead judgment insofar as disqualification law is concerned, where the constitutional bench headed by Justice M. N. Venkatachalaya took up this issue of validity in Quixoto Olohan versus Zakilu. Now, this is a landmark case, 1992. The judge reported judgment you will find in 1992 Supreme Court cases. Now, in this, the validity of the 10th schedule was challenged. It was challenged firstly on the ground that it is not in consonance with Article 368(2) of the Constitution, which is the amending power, as you all know, is the amending power of the Parliament to amend the Constitution itself. That is, 368(2) requires ratification by 50% and more of the states in respect of certain amendments to the Constitution. And one of the amendments is to the powers of the High Court. In case there is any amendment to the High Court or Supreme Court's issue, then there must be 368(2) must be complied with. Ratification is a mandatory requirement. So that was one of the grounds of challenge. The other ground was that paragraph 2(1) provided 1(b) says any direction issued by the political party, which means that this will curtail the freedom of speech and the free right of freedoms under Chapter 3 of the Constitution, Part 3 of the Constitution, and on various other grounds, this amendment was challenged in Quixoto Olohan. Now, the Honorable Supreme Court took up the issue and said, applying the doctrine of severability, severed the paragraph 7 from the remaining part of the 10th schedule and struck it down as being unconstitutional, struck it down as being violative of 368(2) and also being in violation of the basic structure because it interfered with the judicial review power of the High Court under 226 and of the Supreme Court under Article 136. It also further held that the Speaker, while discharging his function under the 10th schedule, is a tribunal. He discharges judicial function and is a tribunal, and his final judgment is open to judicial review both under Article 226, 227 of the Constitution of India and Article 136 of the Constitution of India before the Supreme Court. Now, of course, as you all know, in the latest judgment arising from Karnataka, Article 32 petition also is available insofar as challenge to the judgment of or orders of the Honorable Speaker is concerned. But the division bench also laid a caveat or a kind of a restriction that the challenge shall be only after the final decision is made by the Honorable Speaker or Honorable Chairman, as the case may be, and not before it. So during the pendency of the proceedings, any interlocutory issues or orders that may arise cannot be subject matter of judicial review unless it is so irreversible, unless there is some order, interlocutory order which is passed by the Speaker, which is irreversible and of immediate requirement, and or deals with suspension or an interim order of disqualification. With these two, unless there is, you fall under these two exceptions, proceedings before the Honorable Speaker is not subject, cannot be a subject matter of judicial review. So only the final decision of the Honorable Speaker was a subject matter of judicial review, and that also was for violation of the principles of natural justice, perversity, malafide, violation of the constitutional mandates. On these few limited grounds, the orders or judgments of the Honorable Speakers could be subjected to judicial review. Procedural irregularity in the proceedings of the Speaker could not be a ground. So they took that out of the scope of judicial review. And Kyoto alone in this way laid down a comprehensive law on all these issues. And thereafter, a series of cases of disqualification have come up. Ravi S. Nayak is another lead judgment because this is very important judgment for the reason this is 1994 supplement Supreme Court cases. This is very important judgment for the reason that it interpreted the provisions of paragraph 2 insofar as voluntarily giving up membership of the political party is concerned, and said that an inference can be drawn by the basis of the conduct of the member as to whether he has given up the voluntarily given up the membership of the political party or not, which means that it need not only limit itself to resigning from the political party, remaining as an elected member of the legislature party. See, as I already said, the interpretation clause paragraph 1 deals with two concepts. One is the original political party and the legislature party. So the original political party from which you have been elected, you got to remain a member of that original political party as long as you remain a legislature party member of that political party. So if let us take an example of the Congress party, let us say the Congress legislature party, I am an elected member of a Congress legislature party, I must continue to be a member of the original political party. Therefore, the interpretation of paragraph 2(1)(a), which is voluntarily giving up the membership of the political party from which original political party from which he was elected, was interpreted in Ravi B. Nayak's case, and the Honorable Supreme Court said that by inference, by conduct, the Speaker can arrive at a conclusion that this elected member has voluntarily given up his membership. To cite some factual examples, if an elected member of a Bharatiya Janata Party were to sit in the legislature party meeting of the Congress with the Congress political party's flag, or walk around in their public meetings wearing their flag, wearing their symbol, then or participate in public meetings and canvass for them, then the Speaker, in respect of his conduct which is totally outside the House, can draw an inference that he has voluntarily given up the membership of the political party from where he has been elected. So this interpretation for the first time came up in Ravi B. Nayak's case, which arose from the Goa Legislature Assembly. Another issue which came up for discussion in that case was whether an interim directions, again in terms of the interpretation made in Kyoto Holland's case, whether the High Court can interfere in the interim orders passed by the Honorable Speaker. Because in that case what had happened is, pending disposal of the disqualification proceedings, the Honorable Speaker had accepted the merger of the 5 MLAs. So that merger was challenged on the ground that pending disposal he could not have done it. And also a direction was issued by the High Court in that case to expeditiously dispose of the disqualification proceedings. Now the Supreme Court said that insofar as the acceptance of the merger is concerned, it is hit by Kyoto law and does not fall under the exceptions, which is suspension of a member or irreversible damage done by an interlocutory order passed by the Speaker. So to that extent, the merger, acceptance of the merger was not interfered with, but the direction issued by the High Court to expeditiously dispose of the matter was upheld by the Supreme Court, saying that such a direction can be given by the Honorable High Court. So the law as it stood by the time in the year 1994 was that it is a quasi-judicial authority. It discharges judicial function, the Honorable Speaker. His judgment is, or orders, is subject to judicial review, but subject to the restrictions and exceptions carved out in Kyoto Law and Ravi B. Naik's case. Procedure irregularity was said to be outside the scope of judicial review. Now the question that thereafter arose was whether the Honorable Speaker or Chairman was indeed discharging his functions impartially, and whether he was doing it within time frames, reasonable time frames, and whether indeed the evil of defection was negated or was removed by way of this anti-defection law which is in place. Now several judgments came up. One of the judgments, as Trivikram were introducing me, said was in the case of Balchandra Jarkali versus B.S. Yediyurappa, where, as you all know, in 2010, about 11 elected members of the Bharatiya Janata Party wrote a letter to the governor. What they said was that they had lost confidence in the leader of the legislature party, and therefore please set the constitutional process in motion. Now this was the request. Based on that letter, disqualification proceedings were initiated. Within 3 days, disqualification proceedings were ended, and the Honorable then Speaker disqualified them on the day the vote of confidence or the strength of the majority, whether the government enjoyed majority, the test was to be taken in the floor of the House. Now this went up to the Honorable Supreme Court. Here the disqualification was upheld by the High Court. In fact, firstly there was a divergent finding between Justice Kair and Justice N. Kumar from the division bench while dealing with the 11 MLA's case. The issue was that the rules that the Legislative Assembly had made for the disqualification proceedings provided for 7 days to file a reply. Now this entire proceedings had been culminated in 3 days, because in the meanwhile an interim reply had been filed. So Justice Kumar said that this lack of period of the entire period of 7 days will amount to denial of the principles of natural justice, and therefore the order of disqualification is bad. Justice Kair said that this is a procedural irregularity, and the rules, procedural rules, cannot circumvent the constitutional power of disqualification of the Honorable Speaker. So there is no grievance with that position of law, that rule is procedural, and the rule being subordinate legislation cannot in any way interfere or circumvent the constitutional power or constitutional mandate of the Speaker under the 10th Schedule. But insofar as violation of principles of natural justice, which Kyoto Law said is one of the grounds for judicial review, the court felt that there was no violation. One of the Honorable Chief Justice, then Chief Justice of the High Court of Karnataka, Justice Kumar, deferred, and it went up to the third judge, Justice Sabayat, the late Justice Sabayat, who held in favor of the disqualification and said that there is no violation of the principles of natural justice. Matter went up before the Supreme Court. Supreme Court allowed the SLP, quashed the disqualification, and said that the Speaker committed a grave error in giving only 3 days time. It also questioned the impartiality of the functioning of the Speaker, and felt that the Speaker was indeed acting partisan in this case and should not have disqualified in such haste and such hurry. So that is one of the reported judgments, and again the scope of judicial review in that has been held by Kyoto Law, and Ravi B. Naik has also been upheld there in that matter. So the law as it stood then was very clear in all aspects. So defection, although could not be totally curtailed or being taken away by the 10th Schedule, to some extent the disqualification being proceedings being a threat, was acting as a threat for MLAs from defecting blatantly. Of course, it did not prevent. I will come to the later judgments now. Thereafter, we are in a position where we are seeing several instances of disqualification. We can take Karnataka for an example. A very indigenous mechanism, I say so with great responsibility, has been adopted by the legislators here, and they overcome the disqualification proceedings and got themselves elected again. Then let us take another very unique example of what has happened in Maharashtra. Now Maharashtra, if we go to Maharashtra, the Shiv Sena and BJP was a pre-poll alliance. They did not fight against each other. There was a transfer of votes. They went together virtually as a single party. Shiv Sena and BJP was a pre-poll coalition, pre-poll alliance. The mandate was of the people was for them, for both of them to form the government together. Post-poll, they break this alliance. And the Shiv Sena just joined with NCP and the Indian National Congress and formed government in Maharashtra. Now, this is a very indigenous way of getting away from disqualification law or defection law. Now, my question is that I ask myself, and a lot of you lawyers must reflect on this, whether this kind of a conduct amounts to defection or not. If it does amount to defection, it is not covered under the 10th schedule. Now, in my respectful view, what happened in Maharashtra was a glaring case. It was a glaring case where the mandate of the people was overcome by political greed, if I can say so, and therefore parties which are otherwise opposing each other and went to the people opposing each other with their programs, came together and formed a coalition government. Now, similarly, let us come to now Karnataka. In Karnataka, elected members of political parties, of different political parties, both Congress and JDS, Janata Dal S, resigned from their membership of the legislature. Now, the matter was taken up by the speaker, where there was a disqualification proceedings against some of them earlier to the resignation, some of them after the resignation, some of them where the resignation issue was kept pending by the Honorable Speaker. The Speaker has disqualified all of them, did not accept the resignation. The question of acceptance of resignation did not come. Now, the Supreme Court in that case, which is Srimant Patil versus this Honorable Speaker of Karnataka, also a deported judgment, directly they went to before the Supreme Court in Article 32. So therefore, judicial review under Article 32 also is now open. So that is also now an expanded scope of judicial review. So judicial review under 226, 227, 136 and 32 as against the final decisions of the Honorable Speaker is open. So that law is settled. Now there the question was, in this judgment of the Honorable Speaker of the Legislative Assembly of Karnataka was, he had disqualified them for the entire period and barred them from contesting elections again. So now that, therefore, it brought into picture several issues, which is of very interesting and very interesting areas of law. So I'll just dwell on this a little longer and kindly bear with me. Now, the Honorable Speaker said that by their conduct, they have left the political party. Also, there were whips which are issued to some of them, they have violated. Their resignation was kept in the back burner. And he said that they are disqualified for the remainder of the period of the House, which means they could not contest the elections. Now, as against all these issues, the Supreme Court dealt with each one of them. Insofar as the disqualification is concerned, which again happened in a hurried manner, in a way, the sufficient time was not given to them as one of the grounds. The Supreme Court said that the disqualification is correct. They upheld the disqualification, that by their conduct and by their, some of them by violating the whip, have incurred the wrath of paragraph 2 of the 10th schedule, and therefore the disqualification is correct. It also said that the power of the Speaker to decide issues under the 10th schedule is absolute. So there is no question, nobody can interfere with that power. If you can recollect, the Supreme Court refused to interfere to even give directions for speedy expeditious disposal of the proceedings or within time frames. To that extent, Supreme Court upheld the sanctity of the Honorable Speaker's power under the scheme of the Constitution, and said that the disqualification orders passed by the Honorable Speaker also cannot be interfered with because it does not fall within the scope laid down by the Honorable Supreme Court in Kyoto law, which is it does not serve from perversity, it does not suffer from malefides, it does not suffer from violation of the principles of natural justice, it is not in violation of any of the constitutional mandate. So since it does not fall within any of these areas, the Supreme Court did not interfere with the disqualification and upheld the disqualification. But what it did do is, insofar as the Speaker disqualifying these members for the remainder of the term, it interpreted Article 191(2) of the Constitution and the Article 191(1) of the Constitution, 364(b) of the Constitution, and said that this power is not vested in the Honorable Speaker. He can only disqualify, but he cannot fix or prescribe a time frame or a term of disqualification, nor can he prohibit them from contesting the election again. For this, the interpretive process adopted by the Honorable Supreme Court was that the disqualification law, insofar as Article 194 is concerned, prescribes that a member shall be disqualified from being a member elected and being a member of the House, whereas the 194(2) only, which is disqualification under the 10th schedule, as well as the 10th schedule, prescribes only from being chosen as a member. Sorry, from being a member. So the distinction was Article 191, 194.1 prescribes from being chosen as from being and being chosen as a member, while 91.2 and the 10th schedule prescribe only from being a member. So the disqualification is only from being member, and they are entitled to be chosen again. Was the distinction in an interpretive process adopted by the Honorable Supreme Court. And in this process, they said that the Speaker's power to disqualify for a particular period of time is not available. They also interpreted another provision of the Constitution, which mandated that a person disqualified under Article 191 or under the 10th schedule cannot be made a minister in the cabinet until he is re-elected. So while interpreting these two provisions of the Constitution, the Honorable Supreme Court felt that the disqualification of the 10th schedule is restricted only for disqualified from being a member and does not disqualify them from being chosen as a member, which means they can contest the by-election again. With that relief, the Honorable Supreme Court decided that matter, and by-election results, as you also, most of them were elected back again, and most of them are also now ministers in the Karnataka State Cabinet. So to this extent, another indigenous method, just like the way in Maharashtra what has happened, another indigenous method was adopted here that has been now followed in Madhya Pradesh, and I think it is being followed elsewhere, I think in Manipal, if I'm not, Manipur, sorry, if I'm not mistaken, where elected members of a political party resign from their membership of the legislative party and then escape the wrath of disqualification and defection and go and contest from the other party. Now this, if this is not defection, just like the way the Maharashtra model has worked out, resignation from being from the legislature party should also, in my view, amount to defection, because once a mandate is given to you by the people, it is your candidature and the political party which you represent jointly, to which the people vote. So therefore, you are bereft of the political party. The candidate could not have been elected individually. Otherwise, you should have been elected independently. So the moment it is a combination of the candidate and the political party, it is inalienable. It cannot be, taken away from each other. So when persons choose to leave the political party, they cannot choose to resign from this political party and then contest from another political party and get elected. That should, in some manner, some mechanism, Parliament must evolve to bring that also within the realm of defection and incur the provisions of the disqualification law. Now, political will, as you seen from the history of defection, political will has always been lacking insofar as disqualification law is concerned. It is because the persons who are occupying the seats of power, who have the numbers, they take benefit of the loopholes in the defection. So the opposition, which harps or which cries from the rooftops with regarding to defection when they are in opposition, act to the opposite, to their contradiction of what they have said when they have the numbers, which is why disqualification law is not strengthened. And the Supreme Court also, within its limitation, has done whatever best it can. Now, in the latest of the judgments that has been passed by the Honorable Supreme Court, Justice Nariman's judgment, his Lordship has said that the impartiality of the Speaker, which is again another issue, the impartiality of the Speaker is a big question mark, because from history we have seen that none of the Speaker, irrespective of the political party to which they have belonged, in Karnataka, if you take, the Speaker of Congress was in Legislature Assembly of both the national parties, have been commented upon by the Honorable Supreme Court, and their impartiality has been questioned. Now, this is a big issue. And if we go back to Kyoto Holohan, the minority judgment of Justice J.S. Verma and one more Honorable Judge, whose name I cannot recollect straight away, both of them, out of the 5 judges bench, the dissenting judgment in fact said that the 10th schedule in whole must go, because there is no doctrine of severability, and if the 7th paragraph it does not fall in compliance with Article 368(2), then the entire 10th schedule should go. This apart, they also found that the 10th schedule is unconstitutional for various other reasons, and they also commented on the fact that the tribunal or the authority who decides the disqualification issue, being the speaker, who will be unable to raise above the political affiliation or the political party to which he belongs, the disqualification law will be rendered toothless. And that comment now, as we see what was done in 92, if we can see now in the last 20 years, 30 years, is coming true. So speakers have been unable to, honorable speakers have been unable to rise beyond the political party to which they have belonged. They have not been able to function neutrally, and the high constitutional office of the speaker has succumbed to political affiliations time and again. Now, therefore, the Honorable Supreme Court in the 2020 February judgment which was passed has said very categorically and recommended to the Parliament that the time has come for suitable amendment to be made to the disqualification law, and the tribunal, which is the decision maker, powers from the speaker must be taken away. An independent tribunal should be constituted, either of retired judges or whoever, but it should be an independent tribunal to decide these cases, and the power of the speaker must be taken away. Now, in this context, several meetings of speakers and of various states have been taking place. Even in Karnataka recently, the Honorable Speaker had called for a meeting to decide on these questions. And this apart, the Honorable Supreme Court has said very categorically in the very same judgment. Let me just very quickly tell you which is that judgment. It is Kaisham Meghachand Singh versus Honorable Speaker of Manipur, 2020 February judgment. The Supreme Court has one aspect of the Speaker's impartiality, said that the Parliament must make necessary amendments, and also issued a direction or a mandate that the Honorable Speaker, save reasonable exceptions, must decide disqualification proceedings within 3 months period. So this whole issue of whether the courts could give directions or mandamus, which will act as an interim during the period where the final decision is not taken place, now that has been put to rest. So the Supreme Court says that the Honorable Speaker must decide disqualification proceedings within 3 months, save exceptional circumstances, which must be recorded in writing. So that mandate is also clear. So the law now, as it stands, is that the Speaker is a quasi-judicial authority for discharge judicial function, open to judicial review on the 4 grounds that I have already said, which is in Kyoto Holowan's case. He must decide this issue within 3 months. Of course, is the high office that he holds is expected to discharge it impartially. But till the suitable amendment comes, Speaker remains the arbiter of the disqualification law or the defection issue, and he must provide for the principles of natural justice and decide this issue. So this is where the law stands. But whether the evil of defection, if you go back to the constitutional amendment, the whole object, aims and objects of the amendment, if you get an opportunity to read, is to ensure that the evil of defection is totally negated and removed from our society, because it is eroding the whole democratic principles on which this country stands. So the democracy, which is a fundamental basic feature of our constitution, is under threat by way of this political defection. And political defections in 99% of the cases is done for the lure of money, lure of power, and with intention of toppling lawfully elected governments, which is not a very ideal situation. Now, if we ask ourselves as lawyers and students of law, if indeed the 10th schedule as it stands now, with the various law and judgments that we have gone through, is indeed curbed the evil of defection, my answer would be a categorical no. It lacks the teeth, it lacks the intent, and it has failed in much less eradicating defection, even in curbing defection. Indigenous methods, as we have already seen and discussed, have been adopted by the elected representatives to overcome defection, and the disqualification law has failed in entirety. So few mechanisms that can be evolved is, as the Honorable Supreme Court already said, that an independent tribunal must be constituted, because this will create a very welcoming environment for even voters and active political activists to move the tribunal for disqualification proceedings. Strict time frames must be fixed to complete the disqualification proceedings. Article 191(2) and the 10th schedule must be amended to ensure that the disqualification period is for at least, if not for a period more than the term of the house, at least for that house, it should be prevented from being chosen as a member, being elected, so that they cannot contest the by-election. And the new concept of resigning and recontesting from the other political party, this must be addressed. Pre-poll coalitions must be treated as a single party coalition, and unless these mechanisms are evolved, the evil of defection will continue, and Indian democracy will continue to suffer. With this, I think I have covered most of the areas. If any other questions are available, I am open to answer.
Learned members, Mr. Praveen, I request you to unmute all the viewers so that if they have any particular question, they can place it before the speaker. Mr. Praveen, I repeat, kindly unmute all the viewers so that if they have any particular question,
we have unmuted.
Yeah, thank you.
Hello, sir. Hello.
Yes, sir. Please go ahead.
Hello. Sir, this is Sanjay. Hello.
Yes, Mr. Sanjay, please go ahead with your question.
Sir, this is a question to that, sir. There's one criticism regarding this law. It's banned only retail defections and legalized the wholesale defection. So this act, whether it is empowered the members to defect in proper way, or that is monitoring the defect like this way and that way, or it is really restricting the defection. So I want a personal opinion regarding this criticism. What?
Like I said already, it has encouraged newer methods of defection. Straight away, people earlier to the 10th schedule, people could just walk across. They could cross floors in the house, or they could outside the house just walk into another political party and be recognized with them. To that extent, it worked as a that is no more. That freedom is no more available with the elected members. But of course, they have so many other ways to defect. And like you said, as we are seeing, wholesale defection is permitted, where people are resigning and jumping parties. So there must be some more stringent mechanisms to. Of course, we are an evolving democracy. People will find ways to overcome the law, and that must be covered. And Parliament is responsible. People must create an opinion for this. And one more thing I want to add. You see, now if people who have defected come back, they are, the biggest challenge, as the Supreme Court says in Srimant Patil's case, that their biggest judge is the people. Finally, the elected representatives are judged by the people. Now, the people give them a thumping majority. It vindicates the defection. Otherwise, won by 10,000 votes, defect and come back and win by 30,000 votes. It vindicates their stand.
But still, the amending power rests with the legislators only. So they need to do it, or court must compel. Court cannot compel. At least court can direct it.
Yeah.
Hello.
Yes. Court has already, court has taken several steps, and Supreme Court has now said that the arbiter cannot be the speaker anymore. So let's see what the Parliament does. But at the end of the day, in a democratic setup, people's opinion is most important. Public opinion must be so strong that the politicians are forced to change the law.
Fine. Thank you.
I think Mr. Rangarajan has a question. Yes, sir.
Good evening, Mr. Ponnanna.
Good evening, sir.
In a short span of about 45 minutes, your discourse was both educative and informative.
Thank you.
Now, after hearing you, the long and short of it appear to me as we require sweeping reforms to the election law as such. There is one area which always bothers me. Any person contesting for election, forget the party. First time when he contests, he files his nomination before the Election Commission, declares his income or net worth, let us say 5 crores. Next 5 years, he declares it is 25 crores. Third year, it becomes 100 crores. Now, there is no business on the earth which can multiply money like this. In other words, it is nothing but ill-gotten money or the corruption money. I think somewhere, if each examination paper is taken up for scrutiny by the income tax department or some competent department, I think we can elbow out all the bad elements in the politics. Otherwise, what happens? It has become the money power coupled with muscle power. So, genuine, educated people with no money, no muscle power are not coming forward to enter politics, contest, and serve the nation. So, what are your views?
No, I agree with you, sir. If you see when T.M. Session was the Chief Election Commission,
Exactly.
he brought in several reforms. But nowadays, thereafter, all the election commissions before him and after him have been stooges of the government.
Stooges of the government.
Maybe there may be 1 or 2 exceptions. One, Mr. Krishnamurthy was also quite strong. Otherwise, there was nobody. There is nobody. So unless the election commission, which is the constitutional body, it must function independent. All constitutional institutions, if they function independently, I think some electoral reforms also, as you said, is required. Legislative reforms are required.
I have one more question.
Yes, sir.
Now, these election reforms, I don't think it is going to happen. But everyone has vested interest. Now, my question would be, in the process of interpretation, can the Supreme Court do something to recommend to the Parliament that this is how we expect, people expect you to reform the law? Otherwise, we are not going to see such amendments at all.
Sir, if you see, you know with experience that Supreme Court Article 141, 142 has great powers, and even our Passport Act, even or the Sexual Harassment Act, have all come up after the Supreme Court took up the initiative and passed law.
Correct, correct.
So Supreme Court, of course, has
unfortunately, it concerns the politicians. Therefore, they would not want tampering with their birthrights. Thank you, Ponnanna.
Thank you, sir. Thank you.
It was a great pleasure. Thank you.
Do we have any more questions, members?
Yeah. Can I
Yes,
speak?
please go ahead. Yes, yes.
Yeah. ತುಂಬಾ ಚೆನ್ನಾಗಿ ಮಾತಾಡಿದೀರಾ. This is Sudesh from University of College. ಈಗ ನಮ್ಮ ಸಮಸ್ಯೆ ಏನು, ಆಂಟಿ ಡಿಫೆಕ್ಷನ್ ಎರಡೂನು pertains to democracy. ಅದಕ್ಕೊಂದು ಕಾನೂನು ಮಾಡಿದ್ದಾರೆ. We have the election commission, we have people act. ಈಗ ನಮಗ್ ಬೇಕಾಗಿರೋದು ಸೊಲ್ಯೂಷನ್. Despite all the things that you said, we are unable to find solutions. ಒಂದು immature-ish ಗೆ ಒಂದು ಸಜೆಷನ್ ಮಾಡೋದಾದ್ರೆ, before a political party offers a ticket to a particular contestant, ಒಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೋಬಹುದಾ? ನೋಡಪ್ಪ, ನೀವು ಗೆದ್ದ ಮೇಲೆ ಪಾರ್ಟಿ ಬಿಟ್ಟು ಹೋಗ್ಕೂಡ್ದು. Whether it will attract any of the provinces to the constitution, ultra-virus agutta undo, or whether the Election Commission of India itself can take an action in this taking, or whether the Representation of People's Act alli enadru at least 5 ವರ್ಷಕ್ಕೆ ನೀವು ಗೆದ್ದ ಮೇಲೆ, ನೀವು ಮಿನಿಸ್ಟರ್ ಆದ್ಮೇಲೆ ನೀವು ಡಿಸೈನ್ ಮಾಡ್ಕೂಡ್ದು ಅನ್ನೋ ಷರತ್ತುಬದ್ಧವಾಗಿ ಏನಾದ್ರು ಮಾಡಬಹುದು. ಮೇ ಬಿ
ಅಲ್ಲ, ಒಂದು ಸಿಂಪಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ನನ್ನ ಮೈಂಡ್ ಅಲ್ಲಿ ಇರೋದು. Because I also gave suggestion, this honorable speaker, ಈಗ ಇರೋರು ಕಾಗೇರಿ ಅವರು ಒಂದು ಮೀಟಿಂಗ್ ಕರೆದಿದ್ರು. I did not participate. Some of the participants, like the leader of the opposition, ಮತ್ತೆ former law ministers, ನನ್ನ ಹತ್ರ ಸ್ವಲ್ಪ notes ತಗೊಂಡು, one of the suggestions that I made was that voluntarily giving up membership of the political party ಅಂತ ಏನ್ ಹೇಳ್ತಾರೆ in the paragraph 2 ನಲ್ಲಿ, the resignation from the legislature party or the resignation as an MLA should also be construed as voluntarily giving up membership of that political party and subject him to disqualification. And disqualification must be for the entire period of that house, which means he can't contest the by-election. This will provide a sufficient safeguard and also balance this right of the member for his freedoms of speech or expression. So keeping balance of his fundamental rights under Article 19, as well as the requirement to prevent defection. These two amendments will take care of it. But political will, Rangarajan sir ಹೇಳ್ದಂಗೆ, political will it is not there. So people must create an opinion against it. And that must become part of the common minimum program of the political parties or their manifesto or while going to election, that they will bring in stringent, this is the amendments they will bring in.
I wish you will contest next election. Thank you.
Do we have any more questions?
Sir, may I just ask one small question?
Yes, please go ahead, sir.
Yeah, sir, I'm not a lawyer. I'm just a common man out of interest. I've joined your session. Sir, defection admele. So we are talking about, the elected representative being qualified or disqualified. That is one aspect. So in the process of he being elected and being sent to the governance system, there is a lot of cost involved in it. Should we also not talk about what costs should be recovered from such people who defect from their positions? Is that not a pertinent thing we should also be thinking about, sir? Like, electoral process alli now expenditure ಮಾಡ್ತೀವಿ, elections conduct ಮಾಡ್ತೀವಿ. So then he has been given some house or, whatever facilities that he deserves being an elected representative. So when he defects, should we also not think about recovering costs from such persons? So that's my question, sir.
A very good thought. As far as the cost election expenditure is concerned, it may be right that such expenditure that is incurred by the state from the state machinery that should be recovered, because he is causing a new election with his conduct. So not only the new elections cost must be recovered from him, his earlier election costs also should be recovered from him. See, these are all. If you think about it, there are many methods and mechanisms that can be evolved to prevent this defection and suitably penalize punitive mechanisms for these defectors. But everything, as we said, lies with the representatives themselves. So the people while voting must be careful, and we must insist in the next elections that this becomes a part of every political party's manifesto.
We have any more questions? I think Mr. Satyanarayan sir has a question. Sir, please unmute your line and you can speak. You have muted, so I can see that. Please unmute. So we are not able to hear you. I think you have to unmute. Yes. Now again it is muted.
Okay.
Yes.
Okay. Thank you, Devikram, for the opportunity given to me to talk. You are talking, Mr. Ponnanna, you are talking about the mechanism. One of the mechanism which I wanted to suggest to you is, if a member resigns from the membership, he should not be allowed to contest in the next election. Or on the alternative, the next person should be declared elected. The person who has secured more votes, he should be declared elected when he resigns from the position.
No, that is exactly what I said, sir, that the law as it stands, unfortunately, if we interpret the provisions of 191 and 364B, if I am not mistaken, and the 10th schedule, it does not prohibit him from contesting, and that is what exactly happened in Srimant Patil's case. So the law needs to be suitably amended, and as we are seeing newer and newer ideas that the representatives are coming up with, suitable amendments must be brought. And yes, I agree with you, they must be prohibited and barred from contesting election again. But the idea of declaring the second person elected will again suit the requirement of the ruling party. You see, the defectors, generally they jump to the party which is in power or which can form the government. So if they resign, the person who has lost usually will be the other party. So they will benefit from that also. So, that may not be a very ideal situation. But yes, barring them from contesting again is a need of the hour.
At least for 5 years.
Yes, at least for 5 years.
5 years, he should not be contested.
Yes, I agree with you.
Thank you.
Thank you.
So I personally have a question, sir. As you you had mentioned, Supreme Court under Article 32 is entertaining these petitions. Does the High Court under Article 226, do they have any power, or is it restricted only to the Supreme Court?
No. 226, definitely. 226, 227, that is what I said. I see Kyoto Olawan, Supreme Court said that he discharges a quasi-judicial function is a tribunal. So the power of judicial review, constitutional power, plenary power of this High Court under Article 226 and 227 is very much available.
Very much available.
And that is how 136 is available. And now in the new Srimant Patil's case, they have gone directly under Article 32.
32.
That is also available now. So Supreme Court has opened judicial review, and primarily it is the speakers who are responsible for it by the way they have handled these proceedings.
All right, sir. Thank you so much for a
I have one last question. Hi,
yeah,
Vikram.
please go ahead. Yes.
Sir, it was a great discourse. I really loved it. I just have one small, I want to know your view on the fact that you suggested tribunalization. So won't it add another tier of litigation to the existing system, in the sense that now it is directly a review, now the decisions are directly amenable to the High Court under 226 and 32 under Supreme Court. Now if we tribunalize it, as in you are suggesting that there should be another tribunal, won't it add another tier of litigation? We would much rather have the current system where we are directly going under 226 and 32. What is your view on this? And also on the independence of the, sir, of course, I'm slightly stepping into the political arena. My view is that even the decisions of the Supreme Courts are slightly colored, in the sense that we don't see that level of independence. So if we have another tribunal set up, won't it be, like a post-vacation post for many aspiring judges? On both these aspects, what is your view?
No, when I said tribunal, I meant that the arbiter of the dispute of disqualification should not be the speaker, because he cannot be expected to be partisan. In the last really neutral speaker we saw was Somnath Chatterjee, who was expelled from his political party because he did not toe their line. The CPI, they expelled him as a speaker. So the political parties will not digest a neutral person, even if he is speaker. So the neutrality that the speaker must show is impossible to find. At the end of the day, as Supreme Court has rightly said, the speaker is at the mercy of the majority. So he can be, thrown out if the majority feel that they have no confidence in him. So he is at the mercy of the members whose membership he will decide. So the neutrality aspect being totally absent as we go, and we are only looking at the denigrating morality and we can't expect any speaker of that great character and integrity. So we need somebody who is neutral. So instead of the speaker being the arbiter, let it be somebody else. It does not amount to tribunalization, as you said. And the review under 226 is always open against the tribunal's order. So coming to the second aspect of post-retirement, it need not be the retired judge. It can be a tribunal consisting of some eminent personality, some former political executive fellow also can be there, some officer can be there, anybody can be there. So you need not create a post-retirement situation also. And your third question of independence of the Honorable Supreme Court is concerned. Now that is a matter of perception.
I wouldn't want an answer on that. I was just giving a background.
I will answer that because you see the Supreme Court, irrespective of the criticism that it is facing of late, is the only constitutional institution that has stood up against this what I call as the political treachery. See, against the political oppression of the people, if any institution has stood up to whatever extent, it is only the Honorable Supreme Court. There are aberrations, there are judgments which you will not agree with, which I will not agree with, but that is part of the process.
Thank you. Thank you.
Thank you.
So once again, I thank you for today's valuable session, sir. And not only for presenting the webinar, but you have been very instrumental in conducting these webinars. You have been continuously supporting us from day one. So I would like to thank you for that also. And in fact, today our engineer had to travel back to his native, and your colleague, Mr. Praveen Kamath, has also helped us. So once again, I extend my thanks to Mr. Praveen Kamath and Mr. Arno. So once again, I thank you for everything.
Thank you, Vikram, and I thank the association once again, and I thank all of you for having participated.
Thank you, sir. So with your permission, we are just leaving the meeting, sir. We are logging off.
Thank you.
Thank you.